the data I have, the data public entities, private entities, or any other person has regarding you. You as a data subject, that is your data, your personal data. So at all times, it must be confidential. Yenye wako nayo yako. You don't go to hospitals and find patient files zikiwa juu ya meza where everybody can see, huyu ametestiwa ABCD. No, your data must be kept confidential at all times. So those processors na controllers wanafaa kufuata hizi as they collect and process your data. All those principles. Now, we said one of them was the lawful basis. So let's have a look at what are the lawful basis for processing personal data. And the data we are talking about here is personal data. Ali gave us what the personal data entails. So ni sheria gani ama ni sheria kivipi inawaruhusu to process that personal data? So we'll have number one, consent. Wewe mwenyewe as a person who the personal data belongs to, ukiwakubalisha watumie that data, you have given them the consent. And that consent must be expressed, not implied. Si ati ulikuwa unafikiria nimekubali, no. The data subject must kubali for you to use their data. So that is a consent. Number two is a performance of a contract. If there's a contract that exists between you and an entity, and that contract needs to be performed, then that's a lawful basis. For example, you're an employee of entity A. They need to process your salary. Then, in terms of performance of that contract, the employment contract, that's a lawful basis for which they can process that data. Waweze kukulipa. We have historical and scientific research. If you are doing things for research and scientific and for history, they can process that data via lawfully through that. The other one is legitimate interest. This is for businesses. If a business has a legitimate interest to process that data, basically for commercial purposes. And then we have public authority. This is where all government agencies, the counties, the national government derive their authority from. And then we have vital interests of our data subjects. As a data subject, I might have a vital interest. For example, I'm unwell or something has happened, and you need to collect some data so that you can help that person or that data subject. Then that becomes the lawful basis for processing personal data as a vital interest. Then there's the legal obligations. We have some laws that basically allows us to process some data, and then the public interest. If whatever is being done, for example, a construction of a road is for public interest, then the law allows the entities to collect some data. Now, once we have understood the lawful basis for collecting this data, now we shift back to the people who have that data. We need to know the obligations under the Act. What is it that they can do, or what is it that the Act mandates them to do? What is it that the Act obligates them to do? What the Act obligates them to do, these are the obligations. We have around 9. Number 1 is the registration. As a data controller or a data processor, the first thing they do is to register with the office. It's a fully automated registration process. Doesn't take long. So for all public entities, private entities that process personal data, by DPA Act of 2019, they are supposed to register with the Office of the Data Protection Commissioner. Every 2 years, they renew their registration. Every 2 years. Once they have registered, they will be issued with a registration certificate so that they can now start their compliance journey. Once they are registering, there are things that we check according to just a desktop analysis for what they have said they do, and the office will evaluate if that is sufficient for them to be issued with a registration certificate. The next one is data protection by design or default. Now, we are looking for a way to effectively implement data protection principles such that by the time they start doing anything on data, they have data protection at the back of their mind. That whatever data you are collecting, you know that you shouldn't collect any data in excess. You just use that data for the purpose for which it's required. So it is basically a culture such that we tell entities, whatever data you hold, that's for your data subjects, use it, collect it within the principles of data protection. And the third one is the data protection impact assessment. Basically, this is just an audit of what data do we have within the organization? How are we taking care of our data? What are the risks that we can have from our data in terms of the exposures and all that? These are basically an audit. We'll have a look at it and what they are required to do. The next one is data sharing. In case data needs to be shared, what is the purpose and what are the means of sharing that personal data? Yes, we have a question. Yes. What type of entities? Yes, it's both public and private. Both public and private. And we have a look at registration at the tail end of it, but it's both public and private. There are those who are exempt depending on a few calculations. We'll have a look at that. And we'll also equally have a look at who is not exempt. If you're within some certain sectors, you're not exempt. Telecommunications, we'll have a look at that at the tail end of it. Thank you. So data sharing, sometimes it's inevitable that you have to share some data. So the purpose and the means we'll have of sharing personal data, how do we do about that? That entails that you enter with data sharing agreements to ensure that the data for your data subjects is secured. The other one is the data processor contracts. Remember what we said, that tunaweza kuwa na controller hapa that doesn't control the data. So the controller gives the processor to process the data. So in that giving, you need those contracts so that they are binding, and the contract and the data for your control, your subject is taken care of. And then we'll have a look at the obligations of the data breaches. Data breaches is basically when somebody accesses that data and unlawfully, unauthorized access of that data, whether it's via hacking or an exposure. You're supposed to report within 72 hours. Once you have known that your data has been breached, within 72 hours, you're supposed to report to the data commissioner once you realize that you have a breach within the organization. And then you communicate to the data subjects. Remember, the data being breached does not belong to you, it belongs to the data subjects. Now that that data has been breached, you have an obligation to report to the data subjects of that breach at the same time as you report to the office. The other one is the retention schedules. Now, retention, basically, we are talking about how long should you have that data. Should you have that data longer than necessary, or should you just have your data within the time frames? Remember, we talked about the data life cycles. So you establish a personal data retention schedule with appropriate time limits. When somebody gives you that data, for example, does it mean that you're going to keep it the lifetime? No. So that's the retention schedules that we have. At the end of it all, you can erase, you can delete, or pseudonymize the data, or anonymize the personal data. Anonymize basically means you remove the things that can identify that person. You could have health records data, uko nazo zote, but you could want to remove the name, the date of birth, the ID number, so that you just have the other parts of the data without hizi zingine that can identify that person. Then the data they are supposed to develop data protection policies. In that organization, in that government, in that private entity, in that supermarket, in that hospital, what policy do we have in terms of data protection? How do we protect that data? So you develop and publish data protection policy regarding all this. So, and the final one is obligation of data processors, where you seek authorization of data controllers prior to engaging third party. Hapa kuna data controller, amepatia data processor data yake to process. They are unable to process, so they need to give it to somebody else. They should come back to the controller here and seek what? That authorization within 3 days, so that now they can equally ask another entity to process that data before you enter into that contract. So those are ideally the obligations zote. In one of the obligations we said, moja ni ku-audit. You see, let's say in the morning, wazee wakiamka or akienda kwa his farm, akaa tu hivi, and then he just looks at his farms and then knows what needs to be done. Nini inafaa kufanyika wapi na wapi, eh? That is the same thing as the next one here, which is the DPIA. This is Data Protection Impact Assessment. You are moving from kulipa pesa, cash, to M-Pesa. So you have now moved that transaction from cash to M-Pesa. Now, do you know what are the other risks that hazikuwa kwa cash sasa, but ziko kwa M-Pesa? So that is the assessment that you do. Uko na hospitali. You have health records in files. You want to automate your processes, utoe from files, uziweke kwa system. So there are risks that sasa sababu umetoka kwa file, umeenda kwa system, kuna hizo risks zenye sasa utapatana nazo hapo. So before you do such a huge move, you are being asked to do a DPIA, a Data Process Impact Assessment. Basically, you angalie and you mitigate the privacy risks associated with what you're about to do. That's the DPIA. So it's just a process for the way you do it. Just like the way you just have a look at probably your homestead, unaangalia hivi, unaona hivi, you see this needs to be fixed. Hapa mtu anaweza ingia, mwizi anaweza penya pale, and all that. That's the DPIA for data now. There is a detailed schedule and a process in our website for which you can have a look at it. And then this is the process, basically. You identify ni nini unataka. You have these manual files. What you need to do is to process. But how are you going to process? So you describe the processing, that you are going to transcribe them from those files to the system. Then you will assess the necessity. You identify the privacy risks. Now that umetoka kwa files to computers, what risks do we face there? Then ukijua, for example, ni hacking or an exposure hapo, you mitigate those risks. You can probably have strong passwords, firewalls, policies, and all that. Then from time to time, you keep reviewing and updating that assessment. Still on the same, For any high-risk processing activity, and high risk we mean the kind of data that is likely to get exposed, then you have those impact assessments. Then the other mode is data localization. Your data is being collected here in Kenya. Where do you think that data should be stored? Should it be within the borders of Kenya, or should that entity transfer your data elsewhere? Now, there's a requirement that personal data being processed should be done so through a server or a data center located in Kenya, just within the country. We'll see the reasons as to why. Now, if you cannot do this as a data controller or data processor, then at least you have a copy of that data within here, in such a way that you will never have a time where a data subject needs to access their data or there's a court order that we need to access data A, B, C, D, or there is a public interest. For example, let's talk about the elections. And then for some reason, we don't have that data because the country for which that data is stored is in a different time zones, or it's in a different, or it's inaccessible. If you cannot store all your data locally here, at least you do what? You maintain a copy of the same data here. We'll see the reasons as to why the law allows us to, or basically encourages data localization. So why do we need that, or what could be the reasons for that? These basically are grounds for strategic interests. For example, civil registry from your register of births and deaths. That's data concerning the people. At least they should be within the borders of that country. Then, once you are conducting elections for the representation of the people, there's a very famous case here in 2017. Do we remember that in the Supreme Court ruling? Where an entity couldn't give us access to data because some people are sleeping, I think. Remember that case? So before then, you could get away with that. Now you can't. The facilitation of conduct of elections, of presentation of people, that data should be stored here, or at least you have a copy here if you are going to process it elsewhere. Number 3 is basically administration of public finances. You can't say that the system that administers our finances is not within the country, that it's elsewhere. So those are some of the strategic interests. And the other strategic interest is basically if it's education purposes, secondary or primary healthcare, and any data basically, running a system that is designed to be protected by the Computer Misuse and Cybercrime Act of 2018. So in that previous, we have seen for data localization that you can have your data locally here within. If you are unable to do that, then you can have a copy here and do a transfer elsewhere. So how do we regulate then the cross-border transfer of personal data? Your data is here, and there's a need for it to be transferred elsewhere outside the country. What are some of, how is that regulated? Number 1 is that wherever it's being transferred to must have appropriate data protection safeguards. How is that done? By number 2, adequacy decisions by the data commissioner. Basically, data commissioner has, through the office, have checked that you want to transfer data to country X. How does that country X operate in terms of your data? Do they have safeguards? Do they have an entity in place to protect your data? Do they have an agreement with the body that is sharing? For example, let's say you have a bank X in Kenya, there's another bank Z in a different country, and they want to share that data. Then there are things that they have to check and register with the data commissioner so that an adequacy decision can be given. The other one is transfer as a necessity. If, for example, you have the transfer of your personal data, probably for medical purposes, so that you can continue receiving medical purposes as a necessity, that can be a cross-border transfer of personal data. And then the other one is the consent of data subject. If you, as a data subject, allows them to transfer, then they can do the transfer. And this consent, as we agreed, is an informed consent. It's an informed consent done before the transfer is done. Basically, this is what we are explaining, how the data commissioner basically looks at the countries for which you can transfer the data to. And then almost finally is what we have, the data breach, the one we spoke about, that if somebody illegally or unlawfully accesses your data unlawfully, destroys, alters your data, then that's a data breach, and that must be reported to the data commissioner within 72 hours. And they should communicate to the data commissioner within 72 hours, and to who? The data subjects in writing. In case this happens, basically the data controller processor shall keep a record of the facts relating to that breach. So what happened so that that data was breached? What are the actions that happened prior to, on, and after? And after all that has happened, what are the remedial actions taken? What is it that the organization did after that breach has been done? Now, all that now tells us, just on introduction basis, about who the data processor, who the data controller and data processor is, what are the principles they are supposed to use to collect and process that data. Then we move on to the lawful basis, and then the obligations. And then within that, finally, we need the data sharing or localization. We have looked at all that. But remember, one of the obligations that we said is for the data processor or data controllers to do what? To register. So what is the procedure for that registration? You just apply through our website, www.odpc.go.ke. On the right, you'll see register as a data controller or a data processor. And then you'll fill in the required details. It's a fully automated online process that's quite fast. Then you pay a fee. There's a fee to be paid, a very minimal fee. And then your application will be received by the office. It will be reviewed. And if it meets, approved, and you'll be sent a certificate. Every 2 years, the law requires that you renew every 2 years. So this is basically the process that will happen. The data commissioner will verify, and then you'll be issued with a registration certificate by the data commissioner. There are some of these, the provisions within the DPL are enforceable. They have enforceable things where if you don't do, then there is an enforcement that can happen. So this is basically the registration fee. Ranges from 4,000 to a maximum of 40,000. And this 40,000, this is anybody who is doing well above 50 million in terms of revenue, and you have employees more than 99. And these are all private entities. So number one, number two, number three, these are private entities. So if you are at control or a processor between 1 and 50 employees and an annual turnover or revenue of a maximum of 5 million, that is 1 to 50 and 9 million, you pay 4,000 for registration. Renewal in 2 years, you just pay 2,000. Then if you have 51 to 99 employees and a turnover of 5 million and 1 shilling to 50 million, not more than 50 million, you'll pay 16,000 registration. Renewal, 9,000 in 2 years. And then finally, we have the large data processors. These are people who hold a lot of data for the data subjects. So they have more than 99 employees, and their revenue stroke turnover is more than 50 million. For them, they will pay 40,000 and a renewal fee of 25,000 after the 2 years. Then we have the public entities here, and charities and religious entities. Religious entities and charities register with 4,000, regardless of the revenue or turnover. Why? Because charities and religious organizations hold very sensitive data for their data subjects. Very sensitive. So regardless of the number of employees or the turnover, just register with 4,000 and renew with 2,000. Same applies to all public entities, regardless of how many employees they have, or their annual turnover. Now, that's for registration. Now, let's have a look at those who have to register no matter what. Now, data controllers and processors with annual turnover of more than 5 million shillings and employ more than 10 people are required to do what? To register. Uko na watu 10 employees, and then your revenue or your turnover is more than 5 million. You are required to do what? To register. Now, there are those who do hawaja meet the 10 people or 5 million, but, so the but here now tuisome hapo. A data processor or a controller is required to register regardless of the turnover or revenue, provided they are processing personal data in the following purposes. You see all these purposes. All these purposes, if you're processing data within these purposes, whether or not you have employed less or more than 10 people, or your revenue is more or less than 10 or 5 million, then you are required to register with the office. Number one is canvassing for political support, political parties, gambling. If you are in that business, you are supposed to register. Crime prevention, education institutions, health and provision of patient care. Hospitality industries, but excludes the tour guides. The tour guides don't collect much data. Then property management, including land, provision of financial services, insurance, the digital lenders and all that. And then telecommunication, direct marketing, transport, and businesses that process genetic data. So you basically look at these, these are the people, these are entities or subsectors that process very key, sensitive, personal data. So regardless of their turnover, then they are supposed to register all this because of the sensitivity of the data they process. Then, as we said, we have enforceable provisions within the DPA of 2019. So what are the consequences of non-compliance? Well, the biggest consequence basically here, even without having a look at what the DPA says, is you see the trust the business gives the customers because of knowing that your business conforms to the DPA or protects your data. Basically, that's usually the biggest win for the businesses. But businesses can say, if you give us our data, you'll be assured of a few things. Number one is that that data will be never used for other purposes other than the purpose you have given us. And number two, that will always protect your data. So it's always that trust badge from the clientele that you serve. Now, if that does not happen, basically within the DPA, an enforcement notice can always be issued to a business, to an entity. This is where a data controller, data processor fails to comply with any provisions. There are quite a number of provisions from registration to compliance, inspection, and all that. So basically an enforcement notice is a notice given to a business and entity specifying the consequences for that non-compliance. If that is not done, a penalty notice is issued. The figures that for the penalty notices here are within the DPA, but we have a daily fine of not more than 10,000 for each penalty identified until the breach is rectified. So if something happens, the office will always work with the entities to try and do the corrective measures that we have. An enforcement notice can be given. If that is not complied to, then it will be followed by penalty notices. But in all these compliance issues within the office takes the entities through. They are never in a rush for the penalty notices. The entity will be called upon. We try to review the safeguards that they have, how they protect their data, before a penalty notice is issued. The office is very slow to anger for penalty notices. And then finally is the end of that presentation. So thank you so much.
Tumpe kofi nzuri sasa. Kupea hatu tena. Ine. Mwisho. Sasa kwa hiyo hata nimesema kwa vile kwenye unafanya kazi umeregister kama data processor ama data control. ICT authority umeregister as a controller processor.
Yeah, it's registered.
We have complied, and I think the concern is especially when we are in Garissa. You know, here mostly is the county government. So is the county government registered? Yeah, as a process. Niliona reverend. Kanisa yako imeregister. Niliona ni mandatory. Umeregister? Hayo ni poa. So please ensure that kama wewe penye unafanya kazi ama kama uko na kampuni yako na una fall between hiyo categories zimeonyeshwa hapo, you register. Na hapa kuna mwenyewe ametufunza, muone kama unataka usaidizi kuonyesha vile unafanya registration. So before we invite our next speaker, nataka tusome kidogo to stretch kidogo. Stretch kidogo. So since our next guest speaker, our next speaker, rights of data science. And the next one, your neighbor, the rights. My rights. I mean, data subject. My rights. Has to. Data subject ni mimi na own your data. Sasa nataka tufafanulie tuweze kuelewa. So tutaisha sasa hii si ile vile tulifanya. Iko sababu sasa because of gender diversity sasa. Unaona tu ni Abdullahi atuongelesha, bwana Boni sasa atuongelesha sasa. Kia madam sasa tuambie hata sisi ndio. Haya. Hii ni ile moja tu lakini sasa tutayarisha huku juu. Ingine tunampelekea karibu sana.
Good afternoon. Or is it morning? Good morning.
Morning.
Okay. Good morning. Just to introduce myself. Thank you. I think sauti yangu si kubwa sana. So good morning. To introduce myself once again. Kwa majina naitwa Chepkoech Rotich. I'm an advocate of the High Court of Kenya and I work under the Digital Rights Department, hapo Amnesty. Na leo nitawaelezea kuhusu haki za taarifa binafsi. Yeah, so rights of a data subject. So I think we can get into the presentation, but nilifanya hii presentation in Machakos 3 days, when was it? Last week? Yeah, last week. And I gave myself a challenge during that time to translate the rights from English to Swahili. Yeah, so the Machakos crowd waliniambia nilifanya kazi nzuri, so tuta translate, nitawapea translation yangu, and then, you know, we'll do it as an exercise. You tell me whether I have captured it properly. I don't know, kama kuna watu hapa wanajua lugha Swahili vizuri, so those are people who will help me. So I think let's just get into it. So the rights of a data subject, of course, have to do with the personal data of that person or that data subject. So just to reiterate what Ali had brought up in the morning, what is personal data? So the things that are included in personal data are your name, things like your name, information like your home address or where you work, information like your localization, which is like your GPS information that can be acquired from your phone, your health information, you know, information about your health status, very private things such as your HIV status and other health details, information about your income, how much money you make, how much money your businesses make, information about your cultural profile, right? So this is information about your ethnicity, you know, where you come from, your tribe. So this data tunaita personal and tunazaita pia sensitive, yeah? So nataka, I think this is a question that Ali asked, but I'll ask again. Why is this personal data? You know, so why are we saying that it needs to be protected? Yeah, I know somebody answered and had said that one of the dangers of not protecting your personal data is that somebody can use it to assume your identity, right? Or can use it to hack you. Can someone else tell me another example of why this personal data is so private and needs to be protected? Okay, let me give a specific. For example, why would we need, what is the essence of protecting health data? Yes.
For example,
Yeah.
like somebody who's HIV positive,
Mm-hmm.
he can be stigmatized.
Yes, exactly.
To avoid stigmatization, that person's data needs to be
Protected. Exactly. So that's a very good example. There's a case, actually, I can't remember the year, but it's, I think, before even 2019, involving Catholic University. So Catholic University denied Catholic University sacked one of their employees because they were HIV positive. They subjected that employee to a HIV test and then sacked them. Yeah. So in the end, this employee took them to court, and the court said that they had discriminated against them on the basis of their HIV status, and Catholic University had to pay, you know, about 7 million to that particular employee. But you see, that's an example of how such personal information, if it's accessed, it can be used against you. Yeah. And in the same way that you can use somebody's HIV status to discriminate against them, you can also use their ethnic information, right? If somebody gets a hold of your ID, they will know immediately where you're from. And when somebody knows where you're from, they can assume who you voted for. Sindio? Yeah, so you see such things, it's very private, it's very personal. I mean, my name in Anisema, sindio? Maybe somebody here can assume I'm in which party. Yeah? So that's the kind of that is how sensitive that sitasema nilipigana ni kura but that is how sensitive personal information is. And that's the essence of protecting them. So the rights that I'm about to introduce, hizi haki yenye nataka kuongelea, they are what give effect to this protection. These are the protections that we're talking about, right? So one thing I want us to first establish, for the data subject, these are your rights, right? So these are yours to enjoy, sindio? But for the data controllers and the data processors, these are rights to be respected and upheld in the process of, collecting and processing that data and the way that you operate those businesses, yeah? So it's twofold. For the data subject, you need to know them so that you can enjoy them. And for the controllers, you need to know them so that you can uphold them. So these rights have been extracted from the Data Protection Act, and they all kind of give effect to Article 31 that we talked about, right? Which is the constitutional right to privacy. So we'll go through them slide by slide, but these are the rights. So we can start with the first one. So the right to be informed, haki ya kufahamishwa ama kujulishwa. Iko sawa? Haya. So the right to be informed is the right to be informed about the personal data that has been collected on you. Yeah. So if a controller or a processor is planning to do an exercise in which they're going to collect your personal data, they have to inform you. Yeah. I think before one of the speakers talked about consent. Now, akasema, you have to consent, you have to get the data subject's consent before you collect or process their data. Consent has to be two things. It has to be informed and it has to be freely given. Yeah. So this is basically what that's about. So the data, you have the right to be informed whenever anybody wants to process or collect your personal information. So the right to be informed is an absolute right, right? So you see that some of these rights, some of them are absolute, some of them are not absolute. And the right being absolute just basically means that no matter what, in whichever context, there's no other way. This right stands, yeah? So the right to be informed, this is done at the point of data collection. Of course, it has to be done at the point of data collection. Otherwise, it defeats the purpose. You cannot inform somebody after you've done it, right? So the information must be communicated concisely and in plain language, yeah? So you cannot say that somebody has been informed and they didn't understand. Yeah, you can't say that you have informed data subjects that you're collecting their data, and yet you maybe did it in a very small print, very hard language full of legal jargon, that somebody cannot understand. So you have to inform data subjects in a way that is plainly understood by anyone, right? So that is it on the right to be informed. We can go into the next right. So the second right is the right to access personal data. Yeah. So haki ya kupata taarifa binafsi. Niko sawa ama we can improve? Okay. Sawa. So we can improve. Daniel sawa tunaweza improve. Anaweza nipa nani? Ni hivyo? Okay, sawa. Kama kuna mtu ako na an improvement of it, tunaweza sema njo pia tujue hizi rights in Kiswahili vizuri, si ndio? So, because actually I tried to look for the Data Protection Act Kiswahili version yenye inafaa kuwa hapo on the parliament website haikuwa. So wametuangusha hapo. So anyway, sorry? That was what I was trying to look for. It's supposed to be, in fact, all the laws are supposed to be published in English and Swahili, and it's supposed to be on Parliament's website. And also ODPC, I mean, you should find it for us, you publish it on the website. Yeah, exactly. Higher. So the right to access personal data is an absolute right, and it refers to we've said that this personal data is yours, right? It's your property. You own it. Yeah. So at any point, you have the right to go to a controller or a processor and to ask them, let me see the information that you have on me. Yeah. Let me see the personal information that you collected. And you could be accessing this for many reasons. You could be accessing to check the accuracy, which we will see in another, right? Or for whatever purpose. But at the end of the day, this just reinforces, the ownership that you have over that data. Yeah, it's yours, so you have the right at any point to ask. And we've said this is an absolute right. So that means that the data controllers and processors cannot say no when you ask, let me see the information you have. Yeah, they should provide it to you. And according to the Data Protection Act, you put in a request to access personal data, and they're supposed to respond within 7 days, and the request shall be free of charge. So they should never charge you, and they have 7 days to respond. Remember, we give all of these rules because if somebody doesn't comply, you report them. Yeah? Okay, so that is the right to access personal data. We can move into the next one. So the next one is the right to correction. Yes. So this is the right to correction. Haki ya kurekebisha. Very easy. So like we've said, the data controllers and processors will have personal information on you, yeah? But they might have collected this personal information maybe in 2016. Now it's 2023, something has changed, yeah? You have the right to, once you access, remember the last right was accessing. You ask them to see the personal data that they have. Once they show you, you have the right to correct, kurekebisha. Yeah, in case anything has changed. You could have been single at the time they were collecting the personal data. Now you're married. Yeah, so something could have happened. Something could have changed, and you need to correct it. Alternatively, they could have collected the correct data, but they put it inaccurately in the system. Yeah, so you have the right to correction. So a data subject may request correction of any personal information to ensure that the data is accurate, true, or complete. Sometimes the data might not have been complete. Yeah? Yes. This is incomplete data. ODPC. Thank you. Yeah, so I think that was just a typo. So when you put in a request to correction, you can, when you put in a request to correct, you can expect that they are going to ask you for proof. So you will provide supporting documents, right? If you're correcting information about your marital status, you provide your marriage certificate. Those are the supporting documents that you can expect they'll ask for. And as controllers, of course, if you receive a request, you ask for supporting documents. And then a controller and processor have 14 days to rectify that information, and this request shall be free of charge. This, as you can see, is not an absolute right. Yeah. So remember, we've said that a controller, when you exercise the right to correct, a controller can ask for supporting documents. Maybe your supporting documents are shoddy, and they will decline the request. Yeah. So this is not an absolute right, but it's a right, an enforceable right all the same. So where you have been declined, yeah, the data processor shall notify the data subject of the refusal, and they'll provide reasons. Yeah. So I think that's very reasonable and easily understood. So we can go to the next right. So the right to deletion, haki ya kufuta taarifa binafsi, si ndio? Haya. So the right to deletion, you remember we've said again to emphasize, the personal information that is collected on you is your property. Yeah, ni yako. Yeah, so you of course have the right to delete. We've talked about consent. Another thing about consent, because it's freely given, umepea kwa hiari, yeah? So because you've freely given consent, you can always withdraw. right? And this is how you exercise the withdrawal of consent. So you can have your personal information deleted where you feel like that information is no longer necessary. Yeah, because another thing, remember one of the principles that my colleague talked about, you cannot collect information and then keep it indefinitely as a controller or a processor. Yeah, there has to be a specific and limited purpose. So you don't collect information and keep it indefinitely. There is some correction, there is some information that somebody can collect on you that if they don't delete can prejudice you in the future. Yeah, a good example is, for example, if somebody acquired information about your credit from the CRB, yeah, about your credit and financial history. Maybe you had not paid a loan and then they had that information. But now you have since, paid on that loan, you've since been paying your loans, you're no longer under the CRB list. Why should that person still have that information on you? Yeah, because it may be that maybe you want to access another financial facility. The bank is going to refuse. Yeah, so it's important that you exercise the right to deletion where you feel like the information that's had is outdated, is no longer necessary, or they are no longer authorized to retain it, whether or it's irrelevant or it's excessive. Yeah, there are some instances where I think controllers, or let me just say organizations or people, collect data in an excessive manner. Sindio, you go to those, saa zingine you go to like kwa rafiki yangu, when I visit my friend, their apartment, wanaishi kwa apartment, yeah? The apartment building squeezy, they have a policy where they take a picture of your car, number plate, they put your name, your ID, your so much information. I feel like sometimes those instances, that information is excessive. Yeah, because why do you need, for example, like, why would you need my email in that instance? So where you feel like information that's collected on you is excessive, you can request to delete. Yeah. So where the data is required, so this is also not an absolute right, meaning that there are instances where you can request to delete and your request can be denied. And the reasons can be that the data is required for evidence. Yeah. A controller or a processor can decline, and instead of deleting your data, they can restrict the processing. So as a controller, you can say, okay, we're not going to delete this information, but we'll restrict so that it's not processed further. Yeah? Sijui kama tuko pamoja mpaka hapo? Perfect. Haya. Next in, we're doing a marathon. So you have the right not to be subjected to automated processing or decision making. Yeah? So I think hii tunaweza sema ni haki ya kupinga uamuzi kiotomatic. Yeah. So hiyo tutafanya revision. But so automated processing or decision making is basically decisions that are made by systems or softwares or any kind of technology. Yeah? Sijui kama tumesikia artificial intelligence. I'm sure that's all the buzz. Yeah, so that's one of those are the types of automated processing or decision making that we are saying you have the right to not be subjected to that. Yeah, so a good example of automated decision making, I don't know how far this project is going on, but I think it was a year ago, the government was piloting this automated process for children who have finished KCPE. Yeah, so instead of having NEC be the one to decide, the literal employees be the one to decide which student goes to which high school, they are now using an automated process. So one of the issues that came up with this kind of decision making, we had a boy who was from one of a migrant community actually, and unfortunately the automated process put him, or rather the software, put him in a girls' school. Yeah? Now, what happens to this child? You've been put in a girls' school, you're a boy, it's February, you're supposed to report for Form 1. By the time we correct this decision, by the time we tell NEC, this is not a boy, by the time you tell the principal calls Sijui who in TSC, by the time you do that process, you correct this boy has lost maybe a year of school, or maybe a term, yeah? So those are some of the dangers of automated processes. You know, we like to think about technology as objective. Yeah, sometimes you think technology doesn't make mistakes, technology is objective, it doesn't discriminate, but the opposite is true. Yeah, automated decision-making processes actually have a lot of bias issues. Yeah, because these things, at the end of the day, technology is invented by human beings. Yeah, so at the end of the day, people import those biases. Like, for example, how I can explain the case of this boy that we're talking about, yeah? For such an automated process, how you make that software or that system learn how to categorize boys and girls is you feed it names. Yeah, you feed it information. So somebody will come and feed this system like maybe 10,000 girl names, and then it will start to learn, okay, these are names of girls. 10,000 boy names, and then it starts to know those are names of boys and girls. But what happens when the person that's giving out those 10,000 names leaves out an underrepresented community that has very unique names? Yeah, that one now the system will be confused. It will not know if this is a boy or a girl. Another example of how this automated decision-making and AI systems are actually going wrong was in the UK. In the UK, they implemented public CCTV cameras. They put public CCTV cameras near trains, on the streets, and the purpose was for those cameras to use facial recognition to identify fugitives, yeah, people who are being wanted by the law. Now, what happened is that AI system, those cameras, were actually making more mistakes when it came to black men. So they were actually misidentifying more black men on the street as fugitives. And this is back to what I was saying. This is a problem with the way that the people who create the systems feed in the data. So what happened with that case was the people who created the systems fed that system a lot of information, a lot of pictures of white men, the most. And then the next majority was white women, the most. And then black women last, and black men the least. So of course, by the time you're putting those cameras, it already had a bias. It could identify white men and women expertly. But when it came to black men especially, it was confused. Yeah? So those are some of the biases that we really have to start thinking about, because these automated decisions are being used for public services. We are seeing it being used to sort out, you know, which schools Kenyan kids go to school. Yeah, I mean, which schools Kenyan children attend. You know, we are seeing it being used to sort out who is a criminal and who is not. You know, those are such serious public decisions that where there is a bias there, it can be really, really horrible, and it can really violate somebody's rights. Yeah. So anyway, that was just a brief on that. You have the right to not be subjected to this kind of decision making. Yeah. So an individual has a right not to be subjected to a decision based solely on automatic processing. Yeah. So this shall not apply where the decision is necessary for contracting, or is authorized by law, or is based on consent. Yeah. So it's not an absolute right, but all the same, you do have the right to not be subjected to that kind of automated decision making. And the way that you exercise that is, of course, you can ask If you feel that you have been unfairly subjected to an automated process or on automated decision making, you can request to have that process reviewed by a human being, or you can request for reasons. Yeah. So this includes for can be decisions such as even when you apply for a job. Yeah, like for example, Amnesty. When we send out a job application, we get thousands of applicants. There's no person who is going to sit and go through every single CV. So we have to use an automated decision-making process. But if you feel that you have been unfairly subjected to it, you feel that, okay, I think I was refused, I didn't get this job because it was an automated system. Or you oh, sorry, we're not at the last one. So the right to object to processing. Yeah. So you have the, sorry. I can't lie. Machokos walisema, Machokos told me my answer wasn't right. So who can translate this? Haki ya kupinga, what's processing? Hakuna watu wa lugha hapa. Nani alipata A?
Haki ya kupinga.
Usindikaji. Kutobali processing. Naam. Sindio, ni usindikaji. Haya basi. So haki ya kupinga usindikaji. Haya, so you have the right to object to processing. So a data subject like you and me can request the controller or processor not to process all the data or part of their data. Generally, this is for a specified purpose, and objection is absolute where the processing is for direct marketing. Yeah, those people who process your information so as to send you those ads, those SMSs you get from Domino's ama KFC. Ulitumia namba yako kulipa to order food, and then suddenly now you're getting texts. Buy one, get one free. Yeah, you left your number here at Palm Oasis, and then next week they're sending you 15% off Valentine's Day, Christmas, Mother's Day. Yeah, so those are the direct marketing processes that we are saying you have the absolute right to object to that. So if you're receiving any of those messages, just know you have the absolute right to stop it. I think for those, there are some that you can SMS a certain number to stop. So you can exercise that right. And it's absolute. So they should not send you those messages once you say you don't want to receive them. Yeah? So, no, I'm not done. Yeah, so once you put in the request, once you put in the objection, yeah, to that kind of processing, let's say even for direct marketing, they have 14 days to respond. And where they have declined, that's where it's not from direct marketing, right? Because that's the only instance where your right is absolute. So where they have declined, they have to communicate in writing to you and provide reasons for that objection. Yeah. So we can go on. Higher. So the right to data portability. Haki ya kuhamisha taarifa binafsi. Yeah, that's what portability is. Yeah, so portability refers to the transfer of personal information from one system to another. Yeah, so even something as easy, an easy example is like when you buy a new phone, yeah, you remove your backup from your old phone using Google, right? You back up to your new phone. That's That is data portability. But it can be something even as big as maybe the government taking information from the old Huduma number exercise to the new legal identity that they're creating, yeah? So it can be as big as that or as small as what I've just said. So this right allows individuals to move, copy, transfer data easily from one controller or processor to another. And the key thing here for processors or controllers is, in order for a data subject to enjoy this right, a data controller or a processor has to save that personal information in what they call a machine-readable format. Yeah, so when you download any documents, I don't know if you ever noticed at the end it says .doc, .csv, .jpg, yeah? So those are the machine-readable formats. So as a data controller or processor, you have to always ensure that the personal information you hold is stored in a machine-readable format, so that the time that a data subject comes to you and they want to exercise their right of data portability, it's possible. Yeah, because those machine readable formats they are kind of like common across most softwares and most systems. So with this right, it has to be acted on within 30 days. So controllers, processors, you have 30 days upon receipt and payment of a reasonable charge. Yeah, a reasonable charge to effect that. So the right to data portability only applies to personal data that an individual has personally provided, where the processing is based on consent or the performance of a contract, or where processing is carried out by automated means. Yeah, so a very easy example of how I have exercised this right this year. I actually contacted my former employer to ask them about my NHF details because I was having a hard time logging into that portal. Yeah, and they provided them for me. So that is the essence of data portability. The controller who holds your data should always have it accessible so that you can copy it and you can transfer it if you need. So is there another right? Oh, erasure. Higher. So I think we're now on the last right. So the right to erasure, or it's also called the right to be forgotten. Yeah, haki ya kufutwa, kusahaulika. Si ndio? Yes, haki ya kusahaulika, yeah, ama kufuta taarifa binafsi, yeah. Oh, but kufuta is deletion. Kufuta, yeah, okay. But tukisema the right to be forgotten, pia ni kusahaulika, yeah. So it's the same, it means the same thing. So remember we've talked about some of the dangers of keeping information for too long, how it can prejudice you. Yeah, so currently right now there's a very big international case going on in the European courts, and it's this guy from Spain who is suing Google because they kept information about his bankruptcy from 1998. Yeah, and it ended up prejudicing him in a more recent transaction. So that case is really cementing the right to erasure. Yeah, so everybody, like we've said, this data is yours. Yeah, so you have the right to erase or to be forgotten. Yeah, I know it's a bit of a paradox, because we say that the internet never forgets, Sindio, but at the same time we have the right to be forgotten. Yeah, so those are just some of, I mean, the internet is run by big tech companies, and then the rights are created by human rights and governments. Yeah, so of course there's that conflict. So the right to erasure, it's also known as the right to be forgotten. So a data subject has the right to request for erasure if the data is no longer necessary for the purpose which it was originally collected, or if the individual withdraws their consent, if the individual objects to the processing of their data, or if it's for direct marketing, or if the individual objects and the process has been unlawful, or is required to comply with a legal obligation. Yeah. So, sometimes there's some information about you that maybe I can say it might not become irrelevant, but it can reach a point where it should no longer be there, like online. Yeah. Like, for example, people who end up getting a government position, maybe in the county, or if you end up getting a judicial position, you become a magistrate or something. Maybe there's a website that has your photos on the beach, or there's a tour company that has you there enjoying yourself, right? Some of that information, it can be that, yes, you consented and everything, but it should not be there because it is harming your representation of an office. Yeah, because at that point, you no longer represent yourself, you represent a public office. Yeah. So those are some of the ways that information which can be kept can actually be prejudicial, and you can exercise the right to erasure, to be forgotten. Yeah. This also applies even to like social media companies, right? If you have we've seen on all social media platforms, you have an account, and that account can be deleted. Yeah. So you have that right. It's supposed to be that that information should completely disappear. Yeah. But unfortunately, the opposite is true. I was telling the Machakos guys, I actually experienced something so crazy this year. Who has heard of the app TikTok? I'm sure so many people know TikTok. Sindio? TikTok? Nani amesikia TikTok app? Huh? Umesikia? You've had. Okay, so ni app kama like naweza weka kama Facebook in a way, kama Facebook, but mostly ni videos. Like young people post videos. So that app, I decided to create an account. I was like, let me try out this TikTok. I went to TikTok, I downloaded the app on my phone, and I tried to now create an account. But it logged me in. Do you get? I did not sign up. Imagine, I've never downloaded this app, and it logged me in. Meaning what? Meaning that there's an existing account on the app. So I actually logged in, and for sure, there were my videos. Yeah, there was a profile. It was called user 01234.99, and there was a profile with like 5 or 6 videos. When I looked at the videos, I realized that these videos were actually videos that I had posted on a different app when I was like 18 years old, like literally so many years ago. Yeah, there was this other app called Musically. So those videos were from that time I posted on that app. So you can wonder how did they get those videos? Yeah, TikTok bought Musically. The company TikTok bought Musically. When they bought that app, they transferred all that personal information, all the accounts that were already on Musically immediately just became accounts on TikTok. Yeah, and that's usually what happens with transactions. If you're buying a social media app, the user accounts are assets. So definitely when you're buying that app, you're buying those assets. Yeah. So imagine that you've bought an account. Me, I'm just here in Kenya. I have no clue. And there I am. There's people liking it, commenting. It's a public account. So I was very shocked, horrified, I can't lie. And imagine those are videos from such a long time ago. I was just a kid. So those are some of the real dangers of when companies don't erase data. Yeah. So anyway, we've talked very broadly about the right to erasure. So a data controller or processor, when a data subject exercises their right to erasure, they have 14 days to respond. Yeah. So I think I've covered it. So I think now we've covered all the rights. Yeah, we've covered the rights as they are under the Data Protection Act. So tumemaliza haki zote. So there are some instances where there are some persons who cannot exercise the rights on their own. Yeah. For example, children and minors. Yeah. Minors and young children, of course, don't have the capacity to actually go to the ODPC, and say, I have the right to erasure. Like, yeah. So of course, those rights are exercised on behalf of children by their parents or their guardian. Yeah, there's also persons who have severe mental or other disabilities that incapacitate them from understanding those rights fully. Yeah, so in those instances, a person who is duly authorized or an administrator can exercise those rights. Yeah, we're talking about administrators. So this is in the instance of rights. I mean, this is the instance of personal information that is associated with the estate of somebody who has passed away. So these rights, I mean, these rights are successive even after death. Yeah. So and then there's other cases where you can authorize another person to exercise your rights on behalf of them. Yeah, for example, if you give somebody what's called power of attorney, yeah, over your affairs, that person can exercise those rights on your behalf. Maybe you're not around, you've gone for a couple of years or something, yeah? So those are the instances where rights, the rights of a data subject are exercised by somebody other than a data subject. And I think that brings us to the end of my presentation. I don't know if there are any questions. I think I want to take questions. I know you want to clap for take questions. Are there any questions? Is there anything somebody has not understood? Ama tu swali yoyote tu. Okay. Oh, we'll have a session for question and answer. So thank you so much. I hope that you have a better understanding of the rights of data science as controllers and processors. I hope you have a better understanding on how to uphold the same. So thank you so much. That's all.